If you passed your citizenship interview, the officer told you everything looks good and you're just waiting for your swearing-in date, I need you to hear something before you assume this is over. That letter doesn't mean what you think it means. And for a small but growing number of people, what happens next isn't a ceremony. It's a notice to appear in immigration court. There are currently over 6,000 N-400 naturalization applications sitting pending with USCIS right now, and the wait times behind that number are genuinely getting worse. If you've filed, or you're thinking about filing, this is exactly the kind of thing you need to understand before you find yourself 3 months past your interview wondering why nothing has happened. Let's start with the number everyone should know, but almost nobody does. National processing times for the N-400 have been climbing steadily, and in the highest volume field offices, cases are now taking 18 to 24 months from filing to decision. Part of that comes down to a genuine surge in applications. Back in October alone, USCIS received roughly 4 times its usual monthly volume, a pattern that tends to show up in election years, when people rush to naturalize before major votes. That surge hasn't fully worked its way through the system yet, and it's part of why the number of cases pending longer than 6 months has nearly doubled in less than half a year. Here's the part that's genuinely catching people off guard right now, and it's not really about the wait itself. Immigration attorneys are reporting a specific, troubling pattern. Someone attends their interview, passes the civics and history test, and the officer tells them everything looks good, that a swearing-in notice is coming within a couple of weeks. Then months pass. Nothing happens. And when they check their case status online, it flips back to something like actively being reviewed, a status that, honestly, tells you almost nothing about what's actually going on behind the scenes. Here's the detail worth sitting with for a second because it's easy to miss. Passing the citizenship test and getting that congratulatory letter has never actually meant your case is approved, not under this administration, not under the last one either. It only means you passed the test. The full decision on your naturalization is a separate step, and it always has been. What's changed recently isn't that rule, it's how often officers are verbally telling people, you're good to go, and then quietly continuing to review the case anyway, sometimes for months. Quick pause here, because if you have an N-400 pending right now, or you're getting ready to file one, this is exactly the kind of update worth tracking closely. Go ahead and hit subscribe and turn on notifications because we're going to keep covering what's actually happening with these delays as more information comes in. Now here's the part that's genuinely serious, and it's rare, but it's happening. In a small number of cases, an N-400 gets denied, and instead of the applicant simply keeping their green card the way denials have historically worked, ICE issues a notice to appear in immigration court instead, arguing the person was never actually a lawful permanent resident to begin with. Attorneys handling these cases are describing this as historically unusual. Denials used to just mean you kept your existing status and could try again later. Now, in a handful of documented cases, a denial is becoming the opening move toward removal proceedings entirely. One pattern showing up repeatedly involves discrepancies between someone's original visa application and their later green card or citizenship paperwork, particularly around group affiliations or memberships. If a form years ago answered a related question slightly differently than a more recent one, USCIS can treat that gap as a misrepresentation, even when the underlying questions were technically worded differently and both answers were accurate. That finding can then become the legal basis for arguing the green card itself was never validly issued, which is a dramatically more serious claim than a routine naturalization denial ever used to carry. There's another emerging pattern worth knowing about too: tax-related character findings. Some applicants have had their case flagged over unpaid taxes even when they're actively on an IRS payment plan. Historically, that alone hasn't been considered a sufficient basis to find someone lacks the good moral character required for naturalization, and attorneys are actively pushing back on these specific denials through appeals. Whether that pattern holds is still playing out, but it's exactly the kind of thing worth knowing if taxes are part of your own financial history. So what should you actually do if any of this applies to your situation? If you're unsure exactly how your green card was originally issued, or whether anything in your immigration history could be inconsistent across different applications, requesting your own USCIS file through a Freedom of Information Act request is genuinely worth doing. It's simpler than it sounds. USCIS has a straightforward FOIA page online, and results for USCIS-held records typically come back in 2 to 3 weeks. Just know up front that a fair amount of what comes back can be redacted, sometimes close to a third of the file, especially anything touching other people's information, and getting a more complete version sometimes requires appealing those redactions separately. If your interview happened and 120 days have passed with no real update, you actually have real concrete options, not just waiting indefinitely. You can contact your congressional representative's office and request casework assistance, File a formal service request directly with USCIS, or, in cases that genuinely warrant it, file what's called a writ of mandamus, a federal lawsuit that compels USCIS to actually make a decision, since the law requires a decision within 120 days of your interview. Attorneys who handle these say it's one of the stronger legal tools available specifically in the N-400 context, and it's common enough that once filed, government attorneys frequently reach out fairly quickly proposing to swear the applicant in promptly if the case is simply withdrawn. Some cases never even make it to a hearing before that happens. It's also worth understanding the filing timeline itself clearly, because getting it wrong by even 1 day matters here. If you got your green card through marriage to a U.S. citizen, and your spouse was already a citizen on the day you received your green card, you can generally file 2 years and 9 months after becoming a permanent resident. If your spouse became a citizen after you got your green card, you need the full 3 years, no early filing allowed. Under the general 5-year provision that applies to most other green card holders, you can file 90 days early, meaning at 4 years and 9 months. File even a single day too early under any of these rules, and the application gets denied outright, not delayed, denied. Here's the honest, bigger picture worth understanding tonight. Most N-400 cases are still moving through the system and getting approved the way they always have. The specific problems described here, unexpected denials becoming removal cases, tax-related character findings, months of silence after a "you're good to go," aren't the majority outcome. But they're becoming common enough that immigration attorneys are actively discussing them as a real emerging pattern, not isolated anomalies anymore. Knowing that these patterns exist and knowing you have real options if you run into one of them matters far more than assuming your case is simply an exception once you hit month 4 or 5 of silence. Before you go, make sure you've hit subscribe and turned on notifications because we're going to keep tracking exactly how these naturalization delays and denial patterns continue to develop. If this video helped you understand something that could genuinely affect your own case, or someone you know who's waiting on their citizenship right now, share it with them, because knowing what your actual options are matters more than just waiting quietly. Thanks so much for watching. Stay informed, stay prepared, and take care.